Good morning, everyone. My name is Arlene Marshall-Hockensmith, and I'm the Administrative Officer of Pennsylvania Legal Aid Network. On behalf of PLAN and our presenters today, I want to thank you for joining us for what marks the 2020 Trial Advocacy Skills Training Series. Typically, this training combines lecture with small work group activities, including role plays, but unfortunately, COVID has prevented us from facilitating this training in the same manner. However, we've done our best to provide you all with a similar experience and included a new training session on virtual hearing practice, something many of you may be doing as a result of this public health crisis. Our training facilitators for the series are Nick Matash, who is a managing attorney at MidPenn Legal Services. We have Rebecca Dempsey, who is also a managing attorney at MidPenn Legal Services, and Erica Lamont, who is the Director of Advocacy at Maryland Legal Aid. Over the next few days, this series of trainings will cover various topics designed to strengthen your law practice skill set. We strongly encourage you to take notes and ask questions using the chat feature. If you experience any technical issues, you should use the chat feature for that as well. During this training, you will be required to respond to a series of poll questions. Some will be attendance poll checks. You will not receive CLE credit for these trainings if you do not respond to the 2 attendance poll checks. We'll make a special comment throughout the training to let you know when you need to respond, yes or no. And during the poll checks, our presenters will continue with their presentations. You will also be asked to participate in some training poll questions. Your responses to those questions will help us facilitate our training discussions. By now, you all should have been automatically muted. If you're not muted, please make sure to go ahead and do so now. Our first session today is entitled Effective Advocacy and Practical Lawyering Skills. Trainers, let's begin.
Well, thank you, and good morning, everyone. Arlene, I'm going to throw you a little curveball. Can you post the first poll question? Because it regards how long people have been practicing and how many hearings they've been doing.
Well, there you go.
There you go. How many hearings? There you go. That's the one. Just to get a sense of what our audience is like today. So while you're doing that, my name is Nick Matash, and I've been an attorney with MidPenn Legal Services pretty close to 20 years now. And I've handled pretty much every case that comes into a typical legal aid office. And I've been a managing, supervising attorney now for at least 10 years. So I've got the opportunity to work with a lot of newer attorneys over the years, and we've developed some, I think, good lessons and good procedures here to help so many I've lost track. That's pretty good. That I think we have some good information to share with you guys today. So the first topic that we're gonna look at is, let's see if my screen will advance. I don't know if you can see that, but the purpose of this slide is to discuss your reputation as a newer attorney and what actually affects your reputation. You know, in law school, they really drill it in our heads that your reputation is very, very important and that you should do everything you can to protect it. But they don't really hit on a lot of, well, what does actually threaten your reputation and where does kind of the roots of your reputation lie? And I think some newer attorneys get confused. I've seen this quite a bit with that concept. For instance, if they have a client who says the wrong thing while testifying, or if they lose their case, they think, oh my goodness, this judge is gonna think I'm just a terrible of attorney. And that's really not how it works. Your reputation is primarily based upon your competency. So whether you know the substantive area of law, whether you know the procedure, whether you're being professional in your dealings with not only your clients and opposing counsel, but just, you know, every time you walk into the courthouse and you go to file papers at Facilitator's office, those same folks that you interact with there will be talking to the judge at some point. And, you know, the sheriff's deputies are the same way. So your reputation is based on a lot of different factors. But just because you lose a case, don't think, oh boy, now this judge is going to think I'm not a good lawyer. I'll share with you a story from my first custody trial years ago. It was in a rural county, and I was so embarrassed. I I prepped this client really well, I thought, like you're supposed to. We went through all the questions. We didn't have too many witnesses. It was a pretty standard custody hearing as far as that goes. But at one point in the middle of the proceeding, we had to take a break so that we could go back in chambers, and I think it was to call a teacher. A teacher was going to testify about how the children were performing in school. And on my way back to chambers, one of the sheriff's deputies pulled me aside and said, hey, Nick, come here. The judge wants me to tell you that she's really freaked out by your client because she keeps taking off her shoes at counsel table. Can you please tell her to stop doing that? And I'm sure my face got beet red. Now, I did talk to her about it, and it didn't happen from there on out, but I was so embarrassed by it. And you can't see through the table. I had no idea she was doing it. Although I had prepped her, I thought, pretty thoroughly. There was no way in the world I had ever anticipated that I would have to remind her to leave her shoes on while she's sitting at counsel table, but that did happen. And thankfully, that judge is still on the bench, and I've been practicing in front of her for many years, and it did not tarnish my reputation at all with her. Things are all good with her, but it just goes to show you that just because there's some things that go wrong that are beyond our control, don't automatically think that that's going to affect your reputation. And then again, focus mostly on your competency and your professional skills. All right. Can I X out of this poll at this point, Arlene?
Yes, you should be able to.
Okay. All right. Very good. Moving on to the next topic, which I think is mine again. Client interviews. Client interviews. What is the purpose of a client interview? In its most basic sense, the purpose is pretty straightforward, right? Our purpose is to gather information, to advise the client. You want to be able to develop some kind of trust with the client throughout this process. It's also important that you cover not only the substantive area of law, but also the procedural, what's going to happen if this does go to a hearing, or if it's a landlord-tenant case. You might talk about if you do lose, what the timeline of events are going to be. You want to be sure to establish the scope of representation. Make sure that you hammer in what you're helping them with and what you're not helping them with. And naturally, potential outcomes and what the fallout from those different outcomes may be. So that's the bare bones of what the purpose of a client interview is. Now, you can talk to 10 different attorneys, and they probably all conduct their interviews a little bit differently. So there is no one tried and true method, but you have to find an interview style that I think suits your personality. Some tips along the way are, you have to understand that our clients, they don't know the law as well as we do. And so they're going to come in and you're going to ask them very broad questions, and they're going to give you answers that sometimes are non-responsive to your questions, or they're going to include irrelevant information to what you're actually there for. And that's perfectly normal. That happens. I know when I go to my mechanics, I go to the garage to turn my car in. I have no idea why my car is broken. I just know that it's not running right. And so I try to explain to the mechanic the best that I can, and then they kind of sift through what's relevant and what's not relevant. And that's the way our clients are when they're coming in. They're not sure exactly what information is perfectly relevant. And I would encourage you to continue to ask those open-ended questions. It's very important that you're conscious of your tone and your demeanor. I would caution you against turning it into a cross-examination of some sort of the client. That's very intimidating. I would also encourage you not to be distracted while you're conducting a client interview, playing on your phone, looking on your computer. Now, we have to take notes, but explain to the client why you're taking notes. A short pencil is better than a long memory, right? Writing something down will help you in case you have to rekindle your memory down the road, that you'll be able to refer back to your notes. And that's the purpose of why you're taking notes. It's not that you're not listening to them. So just be very open with the client. Also be conscious of the form of your questions. Like I mentioned before, you don't want to turn it into an inquisition, of course. But also think about just am I asking this question in a way that's the most fair to the client? So like, for instance, I don't think that this is a good style of question to say to a client is, well, they're saying that you were drinking at this party. Why should I not believe them, right? That's not a good way to phrase that question. It has a certain tone to it. It's assuming that I believe the other side of the story just because they alleged it. A fairer question might be, what are they going to say that you did, if anything, to contribute to this situation? You're keep it open-ended. You're not being accusatory. You're not saying that you believe what the other side is saying. You just want to know what their side of the story is going to be. And just so be conscious of how you're asking your questions, what the substance of your questions are. There's a time and a place for everything. Clients aren't always going to be able to perfectly articulate their situation, and you have to understand that. And then, as always, maybe this might be the most important part of a client interview is after the interview, you should always follow up that interview with some kind of letter to the client that goes over not only what you talked about, but also what you will and will not be doing for them. I'm going to be passing the next slide over
Nick?
to, yes, ma'am.
I have a question for you with respect to client interviews. Question in
Yes.
the chat asks, one moment, I'm sorry. Do you have any specific tips for client rapport or interviewing during COVID restrictions?
Yeah, so it's been really challenging. If your office is like ours, we're not allowing clients to come into the office very much. So a lot of it's been by the phone, over the phone. And so in our office in particular, we cover some rural counties where clients aren't always able, even before COVID, to come into the office. And so we had routinely conducted some over the phone, like initial interviews and some hearing prep that way for some of our cases. And I don't think the process is much different. I think it's just important that you explain to them how things are going to be different. If it's going to be a virtual hearing, what that's going to entail. I think it's important that you explain to them why you have to conduct the interview over the telephone. But otherwise, the same techniques do apply. Some programs may be using Zoom. We're not using Zoom for doing client interviews. If there was a way to do that, that'd be best to have that kind of virtual face-to-face interaction. But as far as your questions and the way that you deal with them, in the back of my head, I always try to remember that I don't want to sound like, if you guys ever go to a doctor's office and you have to conduct one of those pre-screening back and forth with like the nurse, they come and they say, it's just like a list of questions that are just rat-tat-tat one after the other. What's your health history, what heart disease, all these questions they rattle off. And it's so formalistic. There's no humanity to it whatsoever. And so I always try to make sure that I'm not sounding like those folks, to be honest with you, when I'm conducting a client interview. Like, have a conversation with them. And you can do it over a telephone just as easily as you can in your office. I hope that answers the questions. Anybody else have any insights they'd like to share from the panel?
I will add a couple of things. So we're used to communicating with people face to face and looking at them in the eye, and they're used to looking at us. And it may seem very impersonal, like Nick said, to talk over the phone, but if you just are upfront with it and just let them know, I might be asking questions that may seem intrusive. I might, ask questions that you might think, could be offensive, but these are questions that I need to know. They're questions that I ask that are very important to your matter. And that might help them be put at ease since you don't have that personal touch.
Are there any other questions, Arlene?
I will also say that since we're talking about not being able to see our client, make sure that you are letting the client know that you need to have a one-on-one interaction with them, and make sure that there's no one else in the room or in earshot, and explain to them the importance of of maintaining the attorney-client privilege in that manner.
Okay, well, moving on, our next slide is for Erica. That'll be topic 3.
So what does client preparation entail? So first, you definitely need to get information from your client. But you also need to know, of course, what the key topics of your client's issues are. And I kind of start backwards. I kind of start with, okay, what do they want to win? And it's important to get clarity from your client about that, because that could be a moving target, especially if you don't get clarity from the beginning. So what is it that your client wants? So once you know what your client wants, you confirm that with them. Then you have to figure out, okay, how do I get my client there? What laws or what laws apply? What statutes apply? What case law applies? And that kind of comes with you drafting your complaint. What are the elements that I need to be in there? So we're not talking about drafting it right now, but I'm just saying the things that you need to consider when you're drafting the complaint. So when you're trying to figure out what your client need, or I'm sorry, how to get your client what they want, then you let them know what you need to get them what they want. So if they want sole custody, you need to let them know what the criteria is that the court will consider in order to give them custody of their child. And that way they can also help, give you the information that you need. So sometimes though, a client will think they'll try to, I guess, be the attorney and give you, certain information that's just targeted. And what you really need is all the information. You need all the information related so that you can then prepare your case. So that's a little tricky. You need to let them know that even information that they might not think is related. Just tell you the story, give you all the information that you need so you can help prepare them properly. So what information should attorney review with a client? So again, I talked about the statutes, the case law criteria, you're not going to read the cases with them, but the case law criteria, you're going to go over any evidence that preliminary evidence that you think might be helpful, review that information, and absolutely ask questions like, what will the other side say? What do you think is going to be the biggest thing that you're going to have to overcome? What are the challenges with your case? I need to know, and you need to let them know, I need to know so that we can prepare. I am your lawyer. I don't have to say, certain things can be private between us, but I need to know. The worst thing is coming into a trial and being surprised by something that your client should have told you about. So those are things that I'd like to review. You also absolutely review witnesses. Who do you think can testify to this? And you'll explain to them in your preparation, you'll explain to them the importance of witnesses, and you'll explain to them the importance of not, having, duplication in your trial. So you'll talk to them about that. Because they'll want to say, well, this person can, testify to this, and this person can testify to that. And we want to make sure that it's not the same information given to the judge, because judges do not like that. Even if it's coming from a different person, they don't like to hear, the same thing over and over again. And so you need to explain that to your client, because they might, want to have a cadre of witnesses. They might not want to have like 10 or 15 people saying the same thing. So you explain that to them and explain that you're going to pick the person that has the best presentation and the most relevant information. So is it possible to over prepare your client and a potential witness? it is, but I'd rather over prepare than under prepare. So the way you over prepare your client is if you give them too much information and critique too many little things with them, focus on the big things with your client when you're preparing them, and not don't get into a lot of minutia with them unless they're extremely important facts, right? Then that's not minutia. But when you're also talking about the witnesses, focus the witness on the information that they need to give, right? And don't, if you over prepare people, then sometimes they can, sometimes it'll backfire, because they'll be critiquing everything they say, and they'll come across as non-authentic to the judge. And so it's very important to just focus them on the things that they need to be prepared for, what the other side is going to say, what they need to, what information they need to provide for the court. And then you won't worry about, and then, you won't have such an issue with over preparing your witnesses. Are there any questions?
Yes, Erica, there's a question in the chat. How do you recover if you were caught by surprise by something at trial?
Okay, so I have a story about that. So my first answer is going to be, don't show any emotion on your face, and just take a breather. So here's what happened to me. I had this client, and he came in maybe a week or so before his trial. He had another lawyer. He probably had like 2 other lawyers. He came in, and we took the case. Of course, explaining to him our limitations. This is when I worked for a private firm. So probably Maryland Legal Aid or your legal services probably wouldn't even take his case, but it's a private firm. And if the client comes in and can pay, basically you're going to take the case probably. So discovery had already been done, and he told me this story about how his wife had railed him into signing this separation agreement, and he didn't really, she just kind of forced it on him. He didn't really have time to prepare. And so I'm, first of all, our case is weak in, to begin with, because he signed the separation agreement. So I'm trying to prove that it was some type of duress that he was under in signing this agreement, so that we can null the agreement. So during the court process, and this person was like a court, he was like a probation officer, so he was very familiar with the court and the judges, right? So we're in the trial, and during the cross-examination of my client, the other attorney hands me this handwritten document, and then he asked my client to identify the document. Well, the document turned out to be his handwritten description of the separation agreement that started the entire separation agreement. So he's the one that created the terms of the separation agreement, but that's not what he told me. So, so what I had to do is when, this evidence came in, he had no excuse as to why, as to why now it's fraud or duress or anything like that, because the terms, he wrote them himself. And so I just didn't show any emotion, and and there was nothing I could do. I couldn't say anything. It's his handwritten, it's his signature, he wrote it. So I did ask for just a brief recess, and I don't remember if I think I just asked for a brief recess and then talked to my client about it. But not, it was kind of like a natural break. It wasn't like as soon as he, presented the evidence that I asked for the recess. It was a little afterwards, because I didn't obviously want to make it seem like, oh, this is, the most horrible thing ever, which it was. But so I waited to a natural break and asked for a little recess and discussed it with my client, and then just tried to recover. I tried to move on from it and tried to refocus my argument on, the fact that the terms were not fair and weren't just. But in the end, my client, the judge was livid at my client and found him and found him not to be credible. And yeah, so you know how that case ended. But basically it's you stay calm, you stay focused, you try to pivot as much as you can with your argument, and take a break whenever you can, but definitely take a deep breath, but don't show any emotion regarding it.
Thank you, Erica.
Yeah.
At this time, we're going to go ahead and launch our first CLE attendance check-in poll. So please make sure that you respond to it, that yes, you are actively participating, or no. Remember, you must respond to these poll questions to be eligible for CLE credit. So we'll leave this on the screen for about for 2 minutes. Erica, you can go ahead and proceed though. Thank you.
Okay. I think we can move on.
Okay. We'll move on to the next slide, which will be a slide for Becky. Is your technology working for us now? You're muted.
Okay, now I can talk. I'm having technological difficulties. Can you hear me now?
Yes.
If you could speak up, I'm not sure if they can.
Okay.
Yeah,
Can you hear me
better
now? Okay. All right. So the topic I have, and I apologize for my technological difficulties this morning. The topic I have is the question of telling the truth. One of the things I always say to clients when we're preparing for trial is that it's very important that you tell the truth about everything when you're testifying, because if you lie about one thing, no matter how small that thing is, then the judge is not going to believe you. So if you testify that you drive a red Mazda, but really you drive a blue Mazda, doesn't make any difference at all. But that lie, if the opposing party says, no, that's not even the color of the car, it's going to make you look like a liar. And if once the judge does not believe your testimony, then that is going to be a problem going forward, even if the lie was something very small. That's an issue I talk a lot about with the clients in family law issues, because frequently one of the issues is, are you dating somebody? So I went to an entire trial on the question of whether or not my client should be able to relocate with the children from Pennsylvania to Maryland. She had always told me that she relocated to be closer to her mother, who lived in Maryland. The other side had always taken the position that she relocated to be with this guy who was, 35 years her senior. She always said that was not true, not true, not true, not true. We went to trial, months and months and months after the original case started. We had all over the pleadings that she was not dating this guy. And on cross-examination, they said, so you moved to Maryland in order to be with this guy? And she said, yes, that is why I moved. So that lie, even though at that point it didn't really make that much difference, completely undermined her position. The other thing I wanted to talk about a little bit is trauma-informed advocacy. And I don't know how many of you have already had training on trauma-informed advocacy. The idea of trauma-informed advocacy is we have to take into account that many of our clients have suffered significant trauma in their lives, and also have suffered significant trauma often with respect to the very thing that you're asking them to talk about. Sometimes you get frustrated when you do a client interview. Let's say you're doing a protection from abuse interview, and you say, okay, so after he knocked you down the steps, what happened? Well, he punched me in the face. And then the next time you talk about it, she says, no, he punched me in the face and then he knocked me down the steps. Now, for purposes of a protection from abuse case, it doesn't really matter if he knocked her down the steps first and then punched her in the face, or punched her in the face and then knocked her down the steps. The important thing for you to understand as a trauma-informed advocate is that she's not lying. It's not that her inability to put the events in a coherent, linear way is a function of the way people experience trauma. If you have ever been in a car accident or have seen a violent incident of some kind, you may recall that you don't remember exactly what happened or in the order in which they happened. So I'm in a car crash, my Jeep turns over, and I'm thrown from the vehicle, and I crawl back in the car to pull my boyfriend out of the car because his shirt was stuck under the roll bar. Now and that actually happened to me. So what I remember about it is I saw we were about to hit the bank, and then I crawled back into the car and pulled his shirt, and then I don't know what happened. The dog somehow also got thrown out of the car. Am I lying? Because I can't remember when things happen. If I don't remember if the dog got thrown out and then I got thrown out, or I mean, I don't remember because it was a traumatic event. And that kind of thing happens with our clients all the time. They don't remember the order in which things occurred, but they do remember it. So when I say, when you're to a protection from abuse client, I will say, you don't have to say this happened, then this happened, then the other thing happened. And if on cross-examination you're questioned about that, you can just say, I don't remember which one happened. I remember he punched me in the face, and here's the bruise, the picture of the bruise that shows that. I remember he knocked me down the steps. I was really upset. I don't really remember which happened. You shouldn't take that as an example of the client not being able to tell the truth or not being able to tell a coherent story. You need to work with the clients and help them present the testimony in the best possible way. And our clients, usually it's not just the traumatic event of being punched in the face and knocked down the steps. Usually there are many traumas that they have suffered in their lives. And the more trauma you suffer, the more difficult it is for you to be on the stand. I don't know if any of you have ever been a witness. I've been a witness a number of times, and it's a terrifying thing. I'd much rather be the lawyer. I would much rather be on the side asking the questions than the person sitting up here answering the questions. So I would just urge you to take that into account when you're dealing with your clients. That's it. Nick, you can move to the next question, next slide.
So the next slide is for me, I believe. If I can get the slide to advance. There we go. All right, trial folder, and what we're going to talk about here are two different kind of trial folders. One is the traditional one, and I pulled out, this is from an appeal that I did earlier this year for an oral argument, and has all the traditional little folders in here that you would have. So this is the record, and it's all tabbed out, as you can see, and I have everything neatly organized and all my points I want to make and all the case law and that sort of stuff that was applicable to that case. I have it all organized and in a way that I will hopefully be able to figure out what I'm talking about when I'm making an oral argument. But there's another kind of trial folder that I think is uniquely useful to legal aid attorneys. And the reason why I say that is many of our cases that we do, there's not a lot of discovery. This is building upon Erica's case where you're just kind of picking up sometimes a case late in the late stages on the verge of a hearing, and you're going into court hearing only half the story sometimes. Sometimes you don't know anything about what the other side's going to say. Like in a lot of family law cases, there's no requirement that they file any kind of answer to pleadings. So you're literally going in only hearing half the story, which is fine, but it also lends itself then to being surprised at a hearing. And that happened to me quite a bit when I was a newer attorney. And new issues sometimes would pop up, issues that I didn't plan for. So I didn't have it in the client files, sometimes like the corresponding case law to a certain issue because I didn't anticipate to be part of the case that was presented. So now, or not now, but back then I developed what I call like these little substantive trial folders. So like this one is for PFAs. So every time I have a PFA case, I grab this folder and the client's file. And in here I have, so this is the PCADV outline, the annotated statute, which is really good. It has all the case law and it's broken out by the sections in the statute. And then I also have all little like related evidence outlines that may be significant to that area of law. Other little outlines that deal with questions that just pop up that you don't anticipate. And so this is kind of like a living document. As I get burned in one case and I realize, oh, I wasn't prepared for that, I better add it to my little substantive folder that I bring with me. And so this is my unemployment compensation one that goes with me to all my cases when I have UC. And again, it has an outline in it. It has some cases that I often will refer to in making closing arguments. There's the evidence rules in the UC cases are kind of different. There's different rules that apply. And so knowing that stuff is really important. Having, like I have my own outline for like the business record exception, because that's normally really important in unemployment cases. And having that available is helpful. And so I would encourage you to just consider doing that for whatever areas of law that you practice in, just having some supplemental information that you bring with you, just in case things go off the rails a little bit. Thank you. We're up to number 6, which I think is Becky. Yes, thank you.
Yes. So I will just follow up on what Nick said about having substantive folders. I think that's an excellent idea. I do that in my practice as well. I have a PFA folder. When I was doing a lot of PFA cases, it just lived in my briefcase. I didn't take it out or put it back in because I did so many PFA cases. It was just always in my briefcase. So if I was leaving my office with my client file, I would have my PFA folder, which, like Nick said, would have the statute, like the Mangle decision on authentication of Facebook posts, collateral estoppel argument, things that would be helpful in a PFA that would be available to me with just in my briefcase. So I think that's an excellent idea. So I wanted to emphasize that as well. So authentic courtroom style. So different people have different styles. And I was just going to spend a couple of minutes describing a few courtroom styles of attorneys that I have observed or known. One example is an attorney who I watched cross-examine my client in Philadelphia. It was a case where there was a criminal case and a protection from abuse matter. I was representing her on the protection from abuse matter, and there was a criminal case, very serious criminal case. He had strangled her and left her unconscious, kind of protection from abuse case, so very serious. So the attorney who cross-examined her at one of the at the preliminary hearing in the criminal case was an attorney who everyone liked because he was a kind of a folksy guy. He was friendly to everybody. Like Nick was talking about being friendly to people. He was friendly to the sheriffs. Very important to be friendly to the sheriffs because they can help you. I mean, a lot of times I've had to call on the sheriffs and ask them to escort my PFA plaintiff out of the courthouse, and how you treat them is going to, make a difference in how much they help you. So he was a friendly guy, well respected. And this client was a particularly fragile woman. And the way he cross-examined her, and I saw him a little bit in some other cases, was a very friendly, non-confrontational, non-aggressive style. So when he asked her questions, he would ask her questions along the lines of, so I'm just trying to understand. When you said that he came into the house and that was at 10 o'clock, but then, so that was at 10 o'clock, right? And so he would do it in a very, I'm just confused. I thought you said one thing and now it seems like you're saying something else, but I'm sure it's just me. You know, so if you could just explain these two different things, and I know how hard this is for you. And he would stop if she started to cry. He'd be like, let me just give you a minute. He'd walk away and he'd offer her a Kleenex. And I mean, he was just like, he was just trying to help her. He was just trying to help her explain. He wasn't at all hostile to her. In fact, he was downright sympathetic to her. He just was trying to make sure that we all understood exactly what happened that night. He's excellent. He was excellent in his cross-examination of her. Now it was still bound over for trial, but he did get some information out of her that he could have used if the defendant hadn't killed himself in the case that was going to move forward. So that's one style. That kind of, I'm just trying to understand. That works really well when you're doing the types of cross-examination that have to do with time frames or different dates or different locations, or you know, it's just a very effective style for him. I mean, that worked for him. But I would say, if you're not a folksy person, then don't try to be a folksy person. You have to figure out what will work for you. Another attorney that I knew well was a district attorney in Franklin County, where I practiced for many years. And his style was more an in-control style. Like, I know exactly what is happening. I know what all the evidence is. I've got it all under control. I've got it all organized. Just listen to me, and you will, and this is in front of juries, you will understand what has happened. And he was so effective in the, when he would get an answer he didn't like, he would act as though, and I saw him do this in a murder trial, he would act as though that was the answer he expected. Like, he got a response from a witness that said something that didn't help his case, and he would just nod his head and like, yeah, that's and then he'd just walk away and go ahead and ask the next question. And his demeanor and the way he responded to it made you think, well, obviously that's not anything anybody cares about, because he's this guy, this well-dressed, you know, kind of confident guy, doesn't care at all about that evidence, so I'm not even going to think about it. I'm going to think about whatever it is he's talking about. So that was another style. That was a well-organized, in control, you know, just worked well for him. Another example of a style is a style that I have used, and I've seen other people use in protection from abuse cases, in cross-examination in particular of defendants. And that is the understanding sympathetic style of, so the defendant says, the question is, did he smack her in the face? So the kinds of questions you might ask are things that show how much you understand how frustrating he could be. So you were upset when she came home at 11 o'clock instead of 9 o'clock. You didn't understand why she would come home at 11 o'clock when she said she was going to come home at 9 o'clock, and you had to put the kids to bed, right? Yeah, I had to put the kids to bed. So, and you have to get up in the morning, right? Yeah. So you didn't get up, and you were waiting for her, and you're waiting for her. When she came home, she was kind of rude to you, wasn't she? Well, yeah, she was. She didn't, you know, when I asked her where she was, she said none of your business. So you were angry then at that point, and then you just build on that too. And I've had tons of defendants admit to me that they punched her because, so, you know, when you got angry, what did you do? Well, I got, you know, kind of red in the face, and then, you know, and then they will often just volunteer that they slapped her because they were upset. They had the right to be upset. But my courtroom style for them is, I understand how you would do a thing like that, because of course you would be mad. Of course she doesn't have the right to, you know, come home at 11 o'clock instead of 9 o'clock. So it's a style that you can use to get defendants to give you information they wouldn't otherwise give you because they think they're sympathetic. You're sympathetic to them. I think how it works for you, now I'm an old white woman. I have a different old white woman style than I had when I was a young attorney, because people respond to me differently. I've had lots of defendants who mistake me for their mother, and will tell me things to try to get me to understand like their situation because of who I am. You have to deal with who you are and work with what works for you, as far as you're interacting with the people. I think it's important to be culturally sensitive to both your clients and the people that you're dealing with in the courtroom in terms of what their experiences might be and how you're interacting with them might play. But it's a style that once you get comfortable, then that can be who you are in the courtroom, and then you just go with what works for you, and then that's going to be something that you're going to be comfortable in the courtroom, which is really important both for you, for the judge, for the clients. If you present yourself as being somebody who's not worried, I'm not worried. We're fine. We're presenting this evidence. I've got more witnesses. I'm not worried. This is good. It's a good negotiating strategy. I've had lots of defendants who will say, I will never agree to anything, and she did these terrible things, and I didn't do anything, and she's the one that's responsible. So I just say, well, okay. And then I go over and sit down, and I just start reading my phone like, I don't care at all. We're going to a hearing. It makes no difference to me. We can have a hearing, not have a hearing. It's all the same to me. Same thing with respect to people who try to intimidate you, and new attorneys are often the victims of hazing by the older attorneys. Older attorneys, or more experienced attorneys, will sometimes say things that just flat out aren't true. Okay, so what we're going to do now is this, and it's not that. First PFA hearing I ever did, an older attorney suggested to me that what I should do is ask for a default judgment or something. I mean, it didn't make any sense. The parties were there, but he was trying to make me look foolish. And I think you have to take it for what it is and not be upset by it. And that's important especially important in the courtroom. If you have an attorney who's being aggressively objecting, you're just going to act like you just respond to it and move on like this doesn't make any difference to you at all. Don't let them show you that you're worried, because you're not worried. You're never worried. You're fine. It's fine. Helps your client. Helps you. Okay.
I will add, if I may, that there's real value to a newer attorney to going and observing other hearings, even if it's not hearings that you would normally see come across your desk. Just seeing how other attorneys go about the process of lawyering in a courtroom is invaluable. And you'll learn lessons that you won't have to learn by making mistakes. I remember when I was a newer attorney doing a hearing one time, and I was going to call a witness, and the other attorney stands up and says, I'd like an offer of proof. And I didn't know what an offer of proof was at that point. The judge looked at me and probably saw like the bewilderment in my eyes and kind of threw me a bone and said, Nick, they said, just what's your witness going to say? And then now I knew what an offer of proof was. But had I gone to like other hearings and maybe saw somebody make that request, I may have known that from learning from somebody else. So it's little things like that you can pick up by just observing other hearings. It goes a long way to seeing different styles. I remember sitting through DUI court when I was interning, and there would be like, I think they could normally do about like 4 or 5 hearings in a day, DUI hearings. They'd do them one after another. And I remember being struck by the fact that there'd be like, it'd be the same ADA, the same assistant district attorney prosecuting the case, and then sometimes it'd be the same public defender doing these cases one after another. And their argument, although the juries would rotate in and out, the attorneys, their presentation was pretty much the same. Like they made the same opening statements, their closing arguments, they used all the same little folksy stories that they used to illustrate, what is circumstantial evidence, and they tell these stories about Joe the mailman or whatever it was, how you don't know that you see Joe the mailman delivering your mail every day, but one day you're not home and it snows and there's footprints that come up to your door. And now you come home and your mail's in the mailbox. You have circumstantial evidence that Joe probably delivered your mail that day. And they'd use that same kind of little story in each one of those closing arguments. And so, it kind of reinforces that there are styles that work for you. There's stuff that's going to be effective for you, and figuring your way through that is part of the process of being a new attorney. And certainly having discussions about these topics with your supervising attorneys is immensely important. Your supervising attorneys are going to know the kind of what the preferences are of the local bench. They're going to know your opposing counsel, and they're going to be able to share insights with you that you won't be able to glean on your own. So ask those questions of your supervising attorneys, and see if you can pick their brain a little bit to help out our clients in the long run.
I think that's really important to take into account the specifics of the particular courtroom. Each judge has different preferences as to, do you mark your exhibits, do you not mark your exhibits? Do you walk up to the front? Do you always have to ask permission to approach the witness? Where does they like you to stand? And all those little things about courtroom etiquette, like in the 39th Judicial District, Franklin Fulton, you always stand to make objections.
Mhm.
So when I started practicing in Philadelphia, I would always stand, and they took that as rude. They were like, counsel, why are you jumping up? And like I was being threatening towards them, and I was just so ingrained in me because I'd spent so much time standing to make an objection. So watching court to see how do we do it in this courtroom? You know, do you hand some courtrooms you have to hand the exhibits to the bailiff, the tip staff, and they'll walk them up. Some places you walk them up. All those little things, and that can get. It's easy to get tripped up and feel like Nick with the shoes example, feel like you did something wrong, and it's not like it's right or wrong. It's just that's how we do it in this courtroom.
And can I just add, those are excellent points you both made. But in addition to that, your authentic style can also change a little bit depending on what judge you're in front of, kind of similar to what Rebecca was just saying, that, for example, there are some judges that I know I can be a little more aggressive with in my presentation, and some that I know that just don't like that. You have to be kind of laid back, and you still represent your client in the way in your authentic style, but it's a little, I might take it down a notch or two depending on the judge. And I will also say that whatever your courtroom style is, like Rebecca was talking about being nice to the sheriff, you need to be extremely nice to the courtroom clerks, because they are they can really make your life lovely or not so lovely. And so make sure that you speak to them when you come in, and you're very polite to them and very respectful. Sometimes I know when I first started out, I would just go in court and I'd be so focused on what I had to do. I really didn't, one time I didn't speak to this clerk, and well, she gave me heck for quite some time. And so I had to be like extra nice to her when I came in, and we mended fences. But it is extremely important for you to be very nice. And I wasn't trying to be, I was just trying to focus. So, but make sure you're nice to everyone in the courtroom, the clerks especially.
And you
Thanks,
can ask them. You can ask them questions. Oh, I'm sorry, Arlene.
No, I just wanted to make mention we need to launch the second attendance launch poll. So we're going to go ahead and do that now. The attendance check will be on the screen for the next 2 minutes. While that's up, Rebecca, go ahead.
What I was going to say is people in the courtroom can also be very helpful to you and can answer questions that you may have. If you appear in a new courtroom or sometimes there's a new judge, and then you haven't been there and nobody in your office has been there either. So you don't have an advanced preparation for what to do. The clerks are going to know, the courtroom staff are going to know. So you can ask them, do I mark my exhibits before I present them? You can ask them, does the judge prefer that I stand back here? Does the judge want me to have my witness, is everybody sequestered all the time? Do we talk about that? And I mean, all those little questions that they can help you with, and they can help. And if they're your friend, they will help keep you out of trouble. And if they hate you and they think you're arrogant and you've been rude to them because you're the attorney, then you can have, and it can take Erica mentioned, it can take a while to get a clerk staff who thinks they've been dissed to come back around. So you definitely want to make that good impression. Thank them profusely for everything they do. to ask them if you can do it a different way that would make it better for them. Like all those kinds of things will help you and help your clients.
I remember when I was a newer attorney, really being unsettled when I'd go into these more rural counties, and we'd go back in chambers before a hearing or something, just to whatever. Sometimes the judges just want to discuss where this is going to go and how long it's going to take, that sort of thing. And then so there's an attorney who's more senior than you who goes into the judge's office first, and the judge is patting him on his back saying, hey, it was good to see you at the club this past weekend, and how are your kids doing? And you have like none of these connections with either one of them at all, and you just feel so out of sorts, and that then that attorney sits down comfortably and starts chit-chatting with the judge, and then makes a transition into all of a sudden they transition right into like a legal argument about the case, and you're like, oh, well, how did we get here all of a sudden? And now they're scoring points with the judge on the case, and you just feel so, I don't know what the word would be, but you just feel like you're not being effective at that point. And just know that happens. It's going to happen to you as a newer attorney. It's beyond your control. I like to think that most judges don't allow their personal relationships with attorneys to influence their decision making in a case. So you just have to stay focused on what your objectives are for that case, and as soon as there's an opening, if you can't elbow your way in otherwise, you be sure to insert yourself into that conversation and score your points that you need to related to the case. But that was always troubling to me early on, was how to maneuver around those circumstances.
And you want to establish yourself as a trustworthy individual. I know one of the judges in Franklin County he felt that one of the attorneys had acted in an unethical way. Now, it wasn't unethical enough to like have him disbarred or unethical in the technical sense of you lose your license to practice law unethical, but the judge thought it was underhanded. And after that, the judge didn't trust him to do anything. I stood and watched one time in court while this attorney, who the judge didn't trust, was standing there with another attorney, and the judge wouldn't even look at him. He asked a question. He says, so where's this document? And this attorney's like, here's a document. And the judge looks at the attorney he didn't trust, and he looks away from him and looks the other counsel, opposing counsel, and asks opposing counsel for the document that was actually the plaintiff's, the guy he didn't trust case. So, I mean, you really don't want to be that guy that the judge doesn't trust anything you have to say. And that's true I was very impressed one time when I saw an attorney in an arbitration. I was on the arbitration panel and they were presenting evidence. And he said something early in his case. And then like a third of the way through the presentation, he realized he'd screwed it up. He'd said the wrong thing. And he stood right up and he said, I just want to correct on the record right now this thing I said earlier. And it was so impressive because you thought, well, what a trustworthy guy. He made a mistake, but he didn't let us think, he didn't like, oh God, I'm so embarrassed, I hope nobody notices. He just says, he stands right up there and says, I want to correct the record. I want to tell you that this document that I said was this, it was this other thing. So that's fine. That is, people make mistakes. And if you have the reputation of somebody who's going to correct mistakes and do what's right, then that's going to serve you well and your clients.
And to piggyback upon that sentiment, this afternoon session, if you're able to attend, is going to focus on ethical issues and when you are conducting a trial. So I hope you're all able to participate in that session as well. Is there anything else from the panel?
No.
Any questions from the attendees, Arlene? I can't see the chat for some reason. Oh, there it is. There's the chat. How do I look at this?
Sorry, Nick, I was trying to unmute myself.
Nope,
There are
you're
no
good.
further questions.
Very good. Well, I appreciate all of your attendance, and I hope you got something meaningful out of this. I know it's a new way of conducting these sessions this year, but we're doing the best that we can to deliver the information that we feel like you guys need, and we hope that you benefit from it and that ultimately our clients will benefit in the long run. Thank you.
Thank you, everyone.
Thank you all.
And hopefully we'll see you at 2 p.m. this afternoon for our next session. Take care.